This afternoon, we'll be speaking about prosecuting international crimes in national courts. So I'm joined by Tina Lai, Transitional Justice Advisor at the Commission on Human Rights in Sudan, and Tabitha Owiya, Head of Civil Rights Division at the Office of the DPP. Now, this morning, we already spoke about international courts and some of the challenges that we face when we have this type of courts, and how national courts provide us with opportunity to be able to do more, go further, and do so at a cheaper cost. One of the benefits that is often cited with national prosecutions is the fact that victims get to see justice being done. This justice is done in a language that they understand. They're able to go to court. They're able to observe proceedings. When we have international trials, this is something that is often quite difficult. Another benefit is that we could also have way more perpetrators being prosecuted before these tribunals, before the national courts. However, we can all agree that however many benefits there may be for national trials, I think we can all agree that they are also not perfect. They also have their own challenges that come with them. And how can we ensure that we have effective, impartial, and independent prosecution of international crimes happening in domestic courts? So these two ladies will join me in conversation as we grapple with some of these issues. And we're going to try and understand exactly how international crimes have been dealt with in certain jurisdictions. We'll, of course, talk about Kenya and the Kenyan experience. So to start us off, perhaps I can start with you, Tabitha, and I'd like to understand the basics. How does the Office of the ODPP deal with international crimes? Do you have a specific division for this? How is this handled?
Thank you so much, Linda. In the Office of the DPP, we are divided into departments. We have a department which deals with conventional and related crimes, under which the DPP has created the Civil Rights Division. Civil Rights Division is charged with the responsibility of dealing with matters emanating from police accountability, and that is where international crimes also falls, and I happen to be the head of that division at this time. So the background to this is that we are operating under the basis of the International Crimes Act number 16 of 2008, which was a creation that came into place after the 2007 incident. And you remember there was a need for Kenya to convince the world that we are able to deal with our issues locally. And the ICC was of the view that we had no legislation in place to handle that. So at least by the time we had a case before us, our principals or the parties were already taken to Hague by the time this act came into place. But I remember that a division was also created in the High Court. It was headed by the then Justice Rawal, retired, and then she also retired soon thereafter. And that division never really took off because we never had cases. But subsequently, we've had post-election violence. More, also very closely, I can say serious, as serious as the 2007. And that is where we find ourselves today. We had the 2017 post-election violence, and we have incidents in Kisumu, and we ended up referring a case, the first case ever registered in Kenya under the International Crimes Act, not specifically to a division, because the Act says the jurisdiction is on the High Court of Kenya. So as we speak today, we have filed a case in the High Court of Kenya, and it is pending. Maybe I can stop there, and then I can wait for further questions or guidance. Thank you.
Kenya has had this history of post-election violence from 2007, 2008, and then you just talked about the 2017 post-election violence. So maybe we can start, from the 2007, 2008. How did the country deal with these cases? And then we can move on to 2017 post-election violence and see the evolution in how the Office of the DPP has been dealing with this.
Okay, thank you so much for that question. Let me say that 2007, 2008 incidents were the worst that have ever been experienced in this country. And the saddest bit is that there was no framework to address them. For a long time, the justice system was thinking within the box, so to speak, that no one imagined that this could be dealt with under the international crimes regime. So there were incidents of torture, murders and killings, sexual-related gender-based violence of the worst nature. And there were the greatest number of victims, even numbering up to thousands. Unfortunately, we had several victims, but no culprits, no suspects, because all the victims and the witnesses could say men dressed in jungle uniform. Men dressed in jungle uniform. And nobody could be held to account. Even our own security system, the police system, they would say, we don't know those people. And it was hard to say where they were deployed from, if at all they were indeed. And that was also a season where we had what are they called, the militia, these militia groups also, who were masquerading as the officers, either from the police or from the army or anything related like that. So it was the hardest moment. And I remember as a prosecutor, I was dealing with the SGBV cases. And we had at one point up to about 800 complaints, which we could not address because we had no suspects. So that was the worst place we have been in. That was 2008, then came 2012. Of course, there were incidents of violence, post-election violence, but a number of them could be addressed under the local framework. And then came the 2017, which was also escalated, and it was bad. And we thought that this time round, there is need for action. So the Office of the DPP directed that an inquest does take place. So we registered an inquest in Kisumu. And pursuant to that inquest, we got a ruling which made findings and certain recommendations. So based on that ruling, we were able to follow up and do some thorough investigations. Now, the investigations that followed after the inquest were unique in that it was a multi-agency approach and it was a prosecution-led investigations. I must also point out that we got the support from international bodies like the OHCHR, who got for us experts and worked with us all the way, just guiding us on what we should look out for. And the matters went back and forth because every time the file came, we would review and say, let's cover this area, let's cover this area. So it took quite some time. But at least with that help, we were able to concretize and say that there is a basis to file a case under the International Crimes Act. And that's where we are today. So for me, it was groundbreaking because it has not been done elsewhere in Africa. Or if it has been done, we have very few examples. Some of the examples that we have are the ICC coming into a certain country to prosecute post-election violence or related crimes, but within the framework of ICC. But in our case, it is under our own legislation, the International Crimes Act. So maybe I can stop there. Thank you.
Tina, I'd like to bring you in now. So we just had that there were over 800 complaints that were made on SGBV and no trials were held for this type of cases. However, when you were working at the Physicians for Human Rights, you filed a constitutional petition on behalf of victims who had been violated, SGBV victims. Can you tell us more about this case?
Yes, sure. Thank you, Linda, and thank you, Tabitha, for that background. I think it makes the transition into discussing the constitutional petition much easier. I think the first place to begin is once the post-election violence had occurred and we had the Kenya National Dialogue and Reconciliation process, a number of mechanisms were proposed to deal with the violence. Amongst those was a commission of inquiry into the post-election violence, which established that at least 900 victims had suffered sexual and gender-based violence. One of the key recommendations of the commission was that the government should set up a special tribunal to conduct further investigations and hold those who bear greatest responsibility accountable for violations, which in fact, in the commission's report, we refer to the commission as the Waki Commission, had risen to the threshold of crimes against humanity. In the alternative, the Waki Commission recommended that if the government failed to set up a special tribunal, then the International Criminal Court should take up the cases, and hence how we ended up with the cases before the ICC, because in fact, we failed to set up our special tribunal. While that was going on, a group of practitioners within the human rights sector, you may have encountered them or worked with them at some point, known as the Kenyans for Peace with Truth and Justice. Numerous institutions, the Kenya National Commission on Human Rights, and many other civil society organizations working together, development partners, were asking themselves critical questions. One being, if the ICC took up the cases, what would be the complementarity mechanism in Kenya? How do we deal with the impunity gap? What types of mechanisms would be necessary to deal with the rest of the cases? So that was question number one. The second question was, how do we shift the focus away from the political rhetoric? Because the ICC cases were about the, if you remember, what were they called? The Ocampo Six. The Ocampo Six were not the victims. It was the political leaders. And the question, therefore, was, how do we then come back and shift attention to the victims, begin to think about justice for the victims and reparations and so on? And thirdly, given the history, which Tabi has just spoken about, that we had had impunity for political violence for decades, and there had not been accountability. The question was, how do we begin to look at accountability or dealing with impunity from a wholesome perspective? That is not merely about taking 6 people to prison, but asking the question, where does the state's responsibility begin? How do we prevent these cycles of violence? How do we ensure that when they occur, we're able to effectively respond? Tabitha had said there were no mechanisms. How do we deal with that? And most importantly, how do we guarantee non-recurrence? And therefore, the case was then born out of this discussion. The SGBV constitutional petition was one. We had 2 other constitutional petitions. Another was framed around police shootings because they had been rampant. In fact, the deaths, majority of the deaths, arose as a result of extrajudicial killings or shootings by the police. And the third case was around IDPs, internally displaced persons. So with Physicians for Human Rights then, we, together with other partners, were co-petitioners in the SGBV case. And here, just to draw a distinction between the constitutional nature, these types of cases versus criminal cases, we really were focused on the state's obligations under the Bill of Rights to do 4 things. Our assertion in this constitutional petition, filed in February 2013, was that the state had failed to meet its obligations on 4 accounts. That the first, the state had failed to prevent the post-election violence, and therefore failed to prevent the occurrence of sexual and gender-based violence in the context of the post-election violence. And we then demonstrated how they failed to train police effectively to conduct human rights-based operations. They failed to preempt based on, we then referred to the Waki Commission reports, saying that there were NIS reports that had actually predicted that there was going to be widespread violence and they had failed to take action. We also then made the second claim, which was even following the violence, the state failed in its obligations to protect victims who had been violated. Many victims of sexual and gender-based violence, especially those who reported that they were raped by police, were turned away from health facilities. They were denied emergency health care. And then we demonstrated that they continued to, in that failure, to provide health care. And third, which is critical then, that leads us to Baby Pendo today, we also made the claim. At the time, the state said there was no evidence to prosecute cases because victims could not identify their perpetrators. There were no suspects. Indeed, under our local law, the Sexual Offences Act, you need to bring an accused person before the courtroom. But in this third obligation to investigate and prosecute, the claim we were making is that the state ought to investigate and prosecute the crimes as international crimes because they were widespread, they were organized, there were a multitude of victims, there were all sorts of barriers that made it impossible for many victims to come forward and report their claims. And so we were stating that the state had a positive obligation with the constructive knowledge in place to investigate and prosecute the sexual violence crimes as international crimes, to attribute responsibility even to the highest level of superior responsibility of those who may have been responsible for overseeing the crimes. And finally, we then also made the claim that the state had failed to fulfill its obligation to provide reparations. And in this, at the time we were filing, the TJRC was about to complete its work, but it had had a lot of challenges along the way. We did not have the confidence at the time, this was February 2013, that there would be sufficient goodwill to pursue reparations through the TJRC. But nonetheless, we then made the claim that the state ought not to repair just the victims who were in this case, but in fact to put in place a comprehensive program that would do an inquiry to really establish, were they 900, were they 4,000, were they 10,000? Where are they? What are their health needs? What are their psychosocial support needs? And how can those needs be addressed? And as I've mentioned, the case was then determined after more than 7 years in the courtrooms. In 2020, December, 10th of December, the High Court did agree with us on a number of these claims, but unfortunately, significant gaps remain, and I'll just highlight them and then finish. The state declared that, in fact, the court declared the state does have a responsibility on all of these obligations. This was the first ever decision from our courts that agreed or declared, affirmed that the state has an obligation to prevent, protect, investigate and prosecute and provide reparations for conflict-related sexual violence. It then went ahead to say there were 8 victims. 3 of these victims were gang raped by GSU officers. 3 of them were gang raped by civilians. 2 of them were children at the time. They were forcefully circumcised by Mungiki militia. 3 of those who were gang raped by GSU, the judiciary determined that the state has, they called it a vicarious liability by virtue of the fact that the police were state actors. Good. Amongst the 3, and only accountable for the failure to investigate and prosecute, not to repair, not to prevent, not to protect. The court did not touch on that. The other 3 who were gang raped by civilians, amongst them, 1 in fact went ahead and reported her claim, but the police failed to pursue proper investigations and to apprehend the suspects. On that account, the judge then also determines that the state is liable for the failure to follow through with proper investigations and prosecutions. The remaining 3, the judge says the state has no responsibility because they were violated by non-state actors, number 1, and number 2, because they failed to report. So for the 4, the state has awarded 4 million Kenya shillings in damages, but no other remedies. We had sought for numerous remedies. Betty was our expert witness speaking on reparations. We had Maxine Marcus, expert witness on investigations and accountability. Rashida Manju, expert witness on prevention. So we really did put up a strong case. So the state says they did not report, and so they can make no claims. And that is where the decision ends. So we have now moved to the Court of Appeal to seek for remedies for the remaining 3, going back to the state's due diligence obligation, that they have a responsibility for both state and non-state actor-perpetrated violations. Secondly, on the question of reporting, coming back to using a lens of international crimes versus contemporary crimes. When there's a breakdown in law and order, do we expect a victim to walk to the next police station? No. What needs to happen? What kind of special mechanisms need to be put in place to ensure that victims are able to access justice? But we're also asserting the legal principle of constructive notice. What has the state done with the TGRC report, with the Waki Commission report, with all of these reports that are actually documenting the existence of widespread and massive violence? And so with the risk of potentially getting into our appeal hearing, I will stop there, but I just thought it would be necessary to give that background. Thank you.
Thank you so much, Tina, for that. Tabitha, you had mentioned the Baby Pendo case in passing, and I know that this case is currently in court, so you're not in a position to, talk about the actual proceedings. But then I think it would be useful for us to understand the thinking of the Office of the ODPP. Why did you decide to, first of all, charge for crimes against humanity in this case? And what was the thinking behind the preparation for the case?
Okay, the kind of violations that play out in the Baby Pendo matter, actually it's Baby Pendo who lost life, but there are many other victims. But what plays out, we are looking at homicide, we are looking at sexual and gender-based violations, we are also looking at issues of torture. We also know that all these were committed during a breakdown of law. And many of these victims, in fact, sometimes I tend to think that if Baby Pendo did not die, probably it may not have gotten this kind of attention that it got. Many of the victims did not come out immediately, but particularly the SGBV victims, they did not come out immediately. We all know that if we were to go by our local mechanism, you want to charge rape, gender-based violence under the Sexual Offences Act, the threshold is high, and we will not get far. It would end up like the 208 cases, because we may not be able to produce medical reports. We may not be able to produce so many details. And the fact that even the circumstances under which these did happen. So we thought that using the international crimes framework will give us the opportunity to even display and show the circumstances under which the violations happened. Oh, she has talked about the presence of those elements of widespread, systematic, against a civilian population, and the authorities having knowledge but failing to do anything to prevent it. And even when it has happened and it has been reported, they did not even take action against the perpetrators. Those kind of circumstances were available in the Baby Pendo situation. So that is what guided us to go the international crimes way. If we were to go then the local way, because the first thing that anyone would ask, Everyone fears the international crimes regime because what comes into their mind is Hague. They see Hague immediately and nobody wants problems. So they ask, but you could just charge with murder. No, it was not just an ordinary death. It's only that the case is in court, so I can't go beyond that. But it was not just death. It was death within certain circumstances. Yeah, so that is what guided us.
So just quickly before we turn over to the audience, I know the PHR Tina has also been involved in other cases in the Congo, and we have the Kavumu cases. Perhaps you can tell us more about these cases.
Yes, the Kavumu case is particularly interesting because it speaks to a number of factors that we want to see existing within an ecosystem that supports survivors to come forward. And once they come forward, that when their cases are documented, they can be supported to pursue justice in a number of ways. So Kavumu is a village in the Democratic Republic of Congo. The case involved a militia group known as Yeshi La Yesu. And they would come into the villages and abduct very young girls, in some cases as young as 18 months. Oldest, I think, was 10 years. And take them to the bush, sexually abuse them, sometimes even killed for ritualistic purposes, and then return them to the forests near their villages. Sometimes they'll be found dead, sometimes alive. And so in the instances that emerged in the beginning, the families would then take the children to Panzi Hospital. You're familiar with Dr. Mukwege and the Panzi Hospital. Physicians for Human Rights worked quite closely with Panzi, and so in terms of medical, legal, forensic documentation, Panzi was very strong on that. So when survivors would come forward, they would document the cases, and they noticed an emerging pattern. Same village, young girls, same pattern of violations. And so when there were a handful of girls, they began initiating reports to the police, to the civil authority, for them to pursue prosecutions. Unfortunately, the civil system failed to take up the cases. And so the military courts took up the cases. This is what Chris was talking earlier about, when military courts actually are the ones that intervene, right? And in the DRC, the military courts have intervened in quite a number of cases. Eventually, 11 people were found liable for crimes against humanity. They actually applied the international crimes framework to hold these perpetrators accountable. 40 girls, they established that up to 40 girls had been raped, some of them killed by this militia group, led by a member of parliament, in fact. The case was determined in 2017. It was appealed. The Court of Appeal upheld the determination. But to get these cases to where they did, first required a lot of enhancement of technical capacity to build the evidence to a threshold that could actually establish this is not a context of conflict, to really demonstrate the systematic pattern of the violations, the organized way in which they were committed by this group. So Physicians for Human Rights, Trial International, American Bar Association, numerous organizations worked hand in hand with the state police and the military court to ensure that that was possible. But other things that also come into play is the protection mechanisms that were put in place. They had to offer safety to, disguise the identity of victims. Remembering the children in this case, they had to have a psychologist to work closely with the survivors. And so I think Kavumu demonstrates that where there is sufficient investment in preparing an ecosystem that is ready to work with survivors, particularly survivors of conflict and related sexual violence, then justice is possible.
Thank you so much, Tina. So I'd like to open up to the audience. Unfortunately, because of time, we'll only be able to take very few questions. So if you have a pressing question, please. Yes, Chalo. And yeah, so I'll take one here, and we'll have 2 more on this side.
My name is Merab Alwach from United States International University, Africa. I wanted to ask this. Recently, African heads of states have threatened to withdraw from ICC. And then also, we understand that ICC only have jurisdiction to prosecute cases within that falls under certain crimes, yeah? So the question is, what next for the victims of, let's say, war crimes, crimes against humanity, and all that, basing that if the African states decide to withdraw from ICC and also anything to do with ICC, what next for the victims, and also how is human rights are going to go about to help the victims of these crimes? Thank you.
Thank you. My name is Owino Michael Ongor from Kenya School of Law. The recent case in Kenya regarding the ICC is whereby Azimio as a coalition party wrote to the ICC about the conduct of the Inspector General. So my question is, why would the coalition bypass this particular department and write a letter to the ICC, yet from what you've told us, Kenya can actually try such a case and even give a conviction? And then another question would be...
I'll have to stop you.
Oh, okay, fine.
Because of
That
time,
one is
so
okay.
we can go to Chalo on this side.
Thank you. Good afternoon. Good afternoon. It's already evening. Tina, how are you? You are the advisor to the government of South Sudan as a commission. No? Okay. I will spare you for that. That was actually my main question. Yeah? I think that was my then I need to redefine my question, because I actually wanted to ask you in regards to your advices to the government of South Sudan as a commission. And then if that's that, I'll not ask.
Okay.
Yes.
So I take the opportunity. Just for both of you, why are you even doing this? I mean, what can you perhaps both of you summarize the advantages of having these efforts to prosecute, investigate, prosecute international crimes domestically? Why are we doing this and not just staying with murder or waiting for other international mechanisms to come in?
Okay, thank you, everyone. So I think we can start with Tabitha, and then Tina, you can close for us.
Okay, it's on. The first question, what was that? What next for the victims? And I think this is very closely, my answer, it's very closely tied to Bettina's question. What next? I think the next thing, what was expected by the internationally for all the countries is to domesticate the International Crimes Act, because the international, what is this called? The International Crimes, it's actually a framework for all the countries to domesticate. So I think Kenya has gone the right direction. The only thing that remains is the implementation part of it. It is never very easy. And even the case that we have just registered in court, it is just a test case, because it's actually going to show us what needs to be put in place. But for me, I would say, to answer Bettina's question, that we need now to wake up to make sure that it works. Because if it doesn't work, then all of us will still be going back to Hague. So we need to have timely recording of complaints. so that to the relevant investigative agencies. We need to put in place mechanisms for timely reporting. We need to have a system for access to prompt and adequate medical care for victims, efficient and timely and effective prosecution of the offenders, human rights-based approach, robust witness protection mechanism, timely determination of cases in court. But what I want to underscore is the fact that no agency can go at this on their own. You cannot walk alone in this. And what has given Baby Pendo a success, as a case to even be registered in court, is the fact that we engaged the multi-agency approach. We worked with various agencies. It was the ODPP, the IPOA, the international, internal affairs unit of the police, Kenya National Commission of Human Rights, and we also involved the civil society. And we've received a lot from the international bodies and civil societies just being there for us. Because remember, these victims still need medical attention. Some of them even talk of HIV issues. Some of them are still mentally still tormented. They need psychosocial support. And even as we proceed to court, we still need this kind of support system. So to me, it will be a wake-up call to all the service providers and all the agencies to work together as a team to achieve this objective that we call justice.
Thank you. Just to add on to what Tabitha said about what next, the framework of the ICC, of the Rome Statute, recognizes that the responsibility lies with states. So the states are the primary actors. The ICC comes in to support states to fulfill their obligation to fight impunity for international crimes. So in an ideal world, we wouldn't need an ICC. However, because there's still a huge challenge in pursuing accountability, especially for those who bear the greatest responsibility, political leaders, military leaders, and what have you, then the ICC was created. Whether or not it's meeting that responsibility is a conversation we can have, but that was the intention. So what next, I think, is really that we must double our efforts to ensure that states are fulfilling their obligations, starting from at home, right? Strengthen political will, strengthen institutions, and all the recommendations that Tabitha was making at this moment. Obviously, there's a lot more that needs to go into that. On Owino's question, I think it just ties in with what Tabitha has just said. As much as the International Crimes Act exists, it was enacted in 2009. It says 2008, but it came into, 2008 came into force January 2009. More than 10 years later, fast case. How many? 2009, 2019, 10, 13 years later is when we have the fast case. So you can see the political will, it takes a lot, as Tabitha is saying. So I'm not speaking for Azimio, but I presume they feel maybe the political will to take up such a matter here may not exist yet. But if we're able to demonstrate through cases such as Baby Pendo, which I believe is such a welcome initiative, then I believe we'll be at a better place in the future. I think Tabitha responded to your question on why we do this. Thank you, Bettina. Thank you.
Thank you both. So join me in thanking these ladies for a wonderful conversation.